Returning to work after a significant leave, whether for family matters or medical reasons, can feel like a major transition. You have diligently followed all the company policies, completed your necessary preparations, and are ready to step back into your professional life with a sense of anticipation. You expect a smooth return to your role. However, if your job reinstatement is denied, it is a serious issue that demands your immediate and careful attention. This type of denial could very well be a violation of your fundamental legal rights, especially if your time off was protected by important federal laws like the Family and Medical Leave Act. You do not have to accept this decision without exploring your options. The core reason why a job reinstatement after certain types of leave is protected lies in laws such as the Family and Medical Leave Act, or FML. This law generally ensures that eligible employees can take up to 12 weeks of unpaid, job-protected leave for specific family and medical reasons. Crucially, it guarantees that upon your return, you are reinstated to your original job or to an equivalent position with the same pay, benefits, and terms of employment. An employer denying reinstatement would typically need to prove a legitimate, non-discriminatory reason, such as a major restructuring that would have occurred even if you had not been on leave, or if you were a key employee and the business would suffer substantial economic injury. So, what steps can you take if you face this difficult situation? First, it is absolutely essential to document everything. Request a clear, written explanation from your employer stating the precise reason for their denial of your reinstatement. Make sure to keep copies of all communications, including emails, letters, and any official forms related to your leave. Second, carefully review the specifics of the leave you took. Was it an FMLA leave, a state-specific protected leave, or a company-provided benefit? Each type of leave comes with its own set of protections and requirements. Understanding your specific rights is your first line of defense. Next, consider sending a formal letter to your employer, ideally through certified mail, disputing the denial. In this letter, refer to your rights under the relevant laws, such as the Family and Medical Leave Act, and request that you be reinstated. Clearly state that you are able to return to work and are prepared to fulfill the duties of your position. While awaiting a response, gather all supporting evidence. This includes medical certifications, any prior performance reviews, and testimonials if applicable. Finally, and perhaps most importantly, seek legal counsel from an employment law attorney. They can review your specific situation, help you understand the nuances of the law that apply to you, and advise on the best course of action. This might involve negotiating with your employer, or in some cases, filing a complaint with the Department of Labor or a state labor enforcement agency. An important detail to remember about the Family and Medical Leave Act is the concept of an equivalent position. This does not just mean a job with the same salary. It means a position that is virtually identical in terms of pay, benefits, and other employment terms and conditions. The job should involve the same or substantially similar duties and responsibilities, and requiring substantially equivalent skill, effort, responsibility, and authority. If your employer offers you a different role that does not meet these criteria, it might still constitute a denial of your reinstatement rights. Be aware that strict timelines often apply to disputing denials and filing complaints, so prompt action is always beneficial. By proactively documenting every interaction, understanding the specific protections afforded by your leave, and seeking expert legal guidance, you empower yourself to effectively challenge an improper denial of job reinstatement. This thorough approach ensures that you protect your career, maintain your financial stability, and uphold your legal rights after taking essential time away from work. Your dedication to your well-being should not come at the cost of your professional future.